Hello, everyone. My name is Pat Harned. I'm the Chief Executive Officer of the Ethics and Compliance Initiative, and it is my great pleasure to welcome you to Impact 2022. We know that the ideal circumstances for us to be together live, as I know all of you appreciate, these are unpredictable times. And so it was a decision by our organization a couple of months ago that we needed to just have one more virtual conference, annual conference together. We're so pleased that you're here, and we thank you in advance for the conversations that you will have, the networking opportunities you will have, for the engagement that we know this community is always really enthusiastic to have, whether we are virtual or whether we are live together. So my task just for the next couple of minutes is to not only welcome you, but to tell you a little bit about the event that you are about to embark on. And first and foremost, many of you may not be aware, but I want to share with you that this is the kickoff to a very important milestone for the ECI. A lot of people don't know that our organization was actually established in 1922. So this year marks the centennial of the ECI. It's our birthday. And so we are using this conference to first announce that it's our centennial. At the end of this morning segment, I'll come back and tell you a little bit about the plans that we have for how we are going to be celebrating throughout the year. Because not only is this a milestone for the Ethics and Compliance Initiative as an organization, it's a milestone for our entire community, and quite honestly, in a lot of ways, a milestone for our profession. So welcome to the birthday celebration, the kickoff of what we think is going to be a really exciting year for the ECI. As many of you know, when we have these conferences, ECI in particular, we have three goals. And the first is to make sure that we are bringing in keynote speakers who are helping to address some of the biggest issues that our organizations are facing today. And I'm really proud of the lineup of keynotes that we have in store for you. You've probably seen the agenda. Hopefully you've seen the agenda on the platform, but just to hit the highlights for you, the ever-pressing priority for our community is always to talk about and hear from the Department of Justice. And so we are really honored to be joined by Lisa Monaco, the Deputy Attorney General. And as you know, as all of you know, one of the biggest things that's looming in our world today is the Russian invasion in Ukraine, the implications for our organizations, especially when it comes to sanctions and caring for employees, adjusting our organizations and our strategies. And so we're very honored to have a panel of both practitioners, experts in cybersecurity, folks who have really done some deep thinking and frankly, real world experience like all of you, to talk about what do we think is ahead when it comes to that entire conflict. So we're pleased to be joined by Luke Dombofsky, Leo McKay, our friend Michael Volkov. They'll be talking about that important topic. We also know ESG is an ever-present discussion in our community. And so one of the most important partnerships that the ECI has created over the last couple of years, number of partnerships, but one of them is with the Public Relations and Communications Association, an international association. Their head, their executive director, Francis Ingham, will be here. As many of us know, PR communications people are active in helping us formulate ESG statements. And so we're pleased to have him come and talk about how they view that topic. And then we also have the general counsel of the SEC here to talk with us about proposed climate disclosure rules and other priorities for the SEC. We also, as we usually do, we have 20 breakout sessions, benchmarking sessions where you can compare best practices, hear from peers about what they're learning, what they're doing in their own organizations, and hopefully you'll take advantage of all of those benchmarking sessions. And then our third goal is always to have opportunities for you to network with each other and to have fun. And so I encourage you at the top of your platform, you'll see a number of tabs that will help you find both a bookshelf of readings that we suggest you check out. One of my favorites are the live cams. I love the jellyfish. Check out the jellyfish in the live cam section. But we'll also be there's a virtual scavenger hunt. And also, as most of you know, we have a high quality program framework. A lot of organizations are implementing that, measuring their programs against it. And we encourage you to come to the HQP brown bag sessions if you're interested in learning more about what that is all about. I also would encourage you to check out the virtual booths. Both our exhibit hall, there's a number of really very loyal and good friends to our organization that have resources available to you. In fact, before I move us into the next segment, I want to take a minute and thank them. As all of you know, these conferences they're not only complicated to plan, but they're expensive to plan. And so we're always grateful for sponsors who come alongside us and help us in that endeavor. And in particular, I want to call out our titanium sponsor, Conversant, our platinum sponsor, Navex, and of course, all of the others, SAI Global. You can see them on this screen, really faithful friends to us, and we're grateful for their support. And with that, I'm actually going to stop sharing my slides and move us into the next segment, which is, I'm sure, of great interest to all of you, and that is our first segment, our conversation with the Deputy Attorney General, Lisa Monaco. And full disclosure, when you work with public officials, it can be really very difficult to get on their calendars and to time their calendars in a way that actually works with the schedule we have planned. And so this segment that you're about to see is a dialogue that I had with Lisa Monaco, and it has been pre-recorded. Prior to our sit down, we sent out a note to our members, invited you to suggest questions that I could pose to the DAG. And so a lot of the questions that you're going to hear me ask of her are ones that came from our community. And so just to kick off this segment, just to briefly introduce Lisa Monaco, though I know she probably needs no introduction. She's the 39th Deputy Attorney General of the United States. The DAG has an important role in the DOJ, essentially serving as the Chief Operating Officer advisor to the Attorney General, but she also oversees the DOJ's litigation, policy, law enforcement agencies, including the 93 U.S. attorneys that report directly to her, and you'll hear her talk about that. Lisa has had a 15-year career as a federal prosecutor, an impressive background. I encourage you to check out her bio on the platform, but she's also served in private practice, has served on boards. You'll hear her mention that. She's a graduate of Harvard University and the University of Chicago Law School. So with that, I'm going to stop talking, allow us to play the conversation we had with the DAG, and then I will be back to move us into the next segment. First and foremost, DAG Monaco, thank you so very much for joining us for our Impact Conference. It's an honor to have you here. We appreciate your taking the time to talk with us.
Well, thank you so much. Thanks for having me. ECI, I think, is a great forum for folks to come together to talk about these issues, and I really appreciate the invitation. So I'm looking forward to the conversation.
So I just want to dive right in because I know you are a busy person. We don't have endless amounts of time. And I just actually want to start by recognizing that you were sworn in as Deputy Attorney General on April 21st, 2021, which means you're 2 days shy of your first anniversary. Happy anniversary.
Thank you very much.
And, you know, as you think about the past year, how would you describe your first year? Has it been what you've expected?
Well, first, thank you for the well wishes on my anniversary. It's strange to think about it as an anniversary since I grew up in the Department of Justice. So it is nearly a year since I returned to the department, but it really very much was coming home to the place where I spent, frankly, the first 15 years, I think all told, of my career as a lawyer. I grew up as a lawyer in this wonderful department. So it was a little bit of a hiatus, but I just came back nearly a year ago. Look, it's been incredibly busy, I think very productive year for the Attorney General, myself, the rest of the leadership team, but most importantly, for the about 116,000 men and women of the Justice Department who, without regard to any timetable, anniversaries, or administrations, just get up and do their work every day with, I think, incredible professionalism and commitment to the values of this institution. And that's what my job is as the COO. We'll talk about corporate roles here. The job of the Deputy Attorney General is to be the COO of the department. And I take very seriously my role as the COO, who at its most basic level, I think, is to make sure the core values of our department are being implemented and applied to all 116,000 men and women carrying out our mission in various ways. You know, the Attorney General has articulated kind of 3 core priorities for the department. It'll come as no surprise to the many DOJ veterans who I know are among ECI's leadership and members. First and foremost, to reaffirm the rule of law, the kind of founding principle of this great department, to protect the American people across all manner of threats that only get more complex and more varied, from cyber attacks to domestic and international terrorism, to rising levels of violent crime, to corporate crime that we'll talk about today. And then, of course, the third priority, but co-equal, as the Attorney General is very fond of saying, because it is in the founding DNA of this department, and that is the pursuit and enforcement and upholding of civil rights across all of the mission spaces for the department. So we've been moving out on all 3 of those priorities and a whole lot else over the last year plus. But it's the men and women of the department who are doing that work every day, as I said, without regard to anybody's particular anniversary, and that's how it should be.
So before we get into some of those specifics of just the priorities of the department, some of the priorities that you've talked about, just want to ask one question about some of your background. When you were a U.S. Attorney in the for the District of Columbia, our audience will be interested, especially to know that you served on the Enron task force, which, as all of us know, ultimately prosecuted several executives from the corporation and also its auditor, Arthur Andersen. For you, what were some of the insights that you gained from that experience? What a great in-depth look at how corporations can go wrong. What are some of the insights that you gained that help you now in your role within the DOJ as you think about prosecuting white-collar crime?
Sure. Well, look, so you're right. As an assistant U.S. attorney here in the District of Columbia, I had the great good fortune of being chosen to serve on the Enron task force, which at the time was, and it was put together shortly after the bankruptcy in December of 2001. That at the time was the largest bankruptcy ever in history when Enron went bankrupt and the company kind of dissembled. I was asked to join the task force. It was put together drawn from assistant U.S. attorneys across the country, working with expert agents and analysts to investigate and prosecute the fraud as a result of the fraud at Enron. So a few things I think that have stayed with me. One, the sheer scope and breadth of the fraud that we found and ended up investigating and prosecuting. That, you know, as I said, it was the largest bankruptcy ever at the time. It permeated a whole host of business lines from the broadband business, which is one of the trials that I undertook, to a deal, an energy barge deal, to you name it. And it rose all the way, of course, up to the top. the CEO, the COO, the CFO, and on down the line. And what it really showed, frankly, and this is something I take with me in this job, and we'll talk about more, culture matters. And what you had at Enron was a culture of greed and hubris. You know, many of your audience will be familiar with what I think was and is still the definitive book on the Enron fraud, and that is The Smartest Guys in the Room. It was a terrific book written by then some Fortune reporters. And, you know, the culture and the fact that it was a culture of greed and hubris permeated the upper echelons and down through. And it was that allowed, I think, the fraud to permeate and to take hold. The other thing I would say is accountability in the form of bringing individual to justice and prosecuting senior leaders, I think is very, very important, because it goes to the core of faith in our system of justice, right? And of course, as everyone knows, corporations, of course, only act through the individuals that populate them. And it was very important, I think, for the Department of Justice to make clear that we were going right up to the top to address those who set that culture and allowed it to take hold. And then lastly, I think, and this here again is something that informs the approach we're taking now and how I look at these issues. We, as I think regulators and as prosecutors, we are of course not the regulators, we're the prosecutors, but I do think regulators as well as prosecutors have a responsibility to make sure we're looking also at the ecosystem that allows the fraud to take hold and continue. So, you know, in the case of Enron, the accountants, the lawyers, right, and the board. These are all aspects that go to making sure there is a culture of compliance and rigor attached to that. And when it's missing, you really get situations like Enron.
It's interesting how some experiences in life you think, how am I ever going to use this again? And what a difference that has made in your own thinking about the job that you have now. It's really interesting to hear about. I want to delve into some of the remarks that you've offered in the past. There's in October of 21, as you know, you spoke at the ABA's National Institute on White Collar Crime, and then you issued a memorandum the same day to announce a number of changes to corporate enforcement policy. And so I'd like to delve into some of the things that you pointed out in both those remarks and in your memorandum. And one of the things that you announced was the creation of the Corporate Crime Advisory Group, the CCAG, that is studying corporate criminal enforcement policies and making recommendations for further changes. And of course, that has been of interest to our community, and I'm sure to many, many others. Can you tell us a little bit about how the CCAG is operating, and to what extent are they seeking input from the compliance community and others in the business community and other stakeholder groups?
Sure. Well, first, thank you for recognizing that no governmental effort is complete without having an acronym. So thank you for acknowledging the CCAG. Was not generated with that intent, but you know, there we have it. We've got a group with an acronym. So the Corporate Crime Advisory Group is something, you're right, that I established last fall with a very specific purpose. One, it is made up of experts within the Justice Department, drawn from all across the Justice Department. So for sure, of course, are prosecutors in the criminal division, but also drawing on experts across the department from our civil enforcement side and antitrust and you name it. We've cast the net quite wide in terms of those who are participating in the department. And that is purposeful as we go about our work to do that outreach and to gather ideas and refinements. So I set it up to make specific recommendations to further refine kind of the principles that I did lay out in the ABA speech that I gave in October. The idea behind that speech was to make quite clear some of the principles that we were going to be pursuing when it comes to corporate criminal enforcement in this administration and in this Justice Department, but understanding that there needs to be further refinement and further guidance, both for our prosecutors and frankly, for GCs, for compliance heads, and frankly, for boards and CEOs, so they know how we are approaching this and what we are looking at as we evaluate corporate conduct. So we created it to have a wide membership within the Justice Department. And similarly, I asked the CCAG to be very deliberate and wide-ranging in the feedback.
One second, everybody, while we try to figure out the technical issue. We're having somebody else start the video, everybody. So again, thank you for your patience. So it looks like it listed the video's frozen for me too, from your screen. So if you pick up at 18 minutes, it should work. And share your audio.
This is about where are you putting your investments. That's how, look, I also, as the COO, I build a budget every year for the Justice Department and have to make decisions about where we're putting our incremental additional dollars, right? Is it on cybersecurity? Is it on civil rights enforcement? How are we showing what our priorities are in any other way other than what we're putting our money on? And so I think the point is also to be able to arm folks to have those conversations and to be able to have informed conversations to drive good decisions in that regard. I also know it can be difficult to have those conversations and really emphasize the need to invest in this space in a kind of time of peace, so to speak, when you're not facing a crisis or you haven't just come out of a particular inquiry and dealing with the government. Because the time, and my message, I think, has been quite clear, and I'll reiterate it again today. The time to invest is now, before you're facing the problem, because quite obviously, that is something we'll take exceptionally seriously, because that indicates a focus from the get-go, not just because you need to, because you're kind of in the barrel, so to speak.
So I'd like to raise a different topic. One of the things you've actually mentioned this a little bit today, but you have reinforced the department's intent to hold individuals accountable in alignment with, or perhaps a hearkening back to the Yates memo. Can you give us a little background on the reason behind that announcement?
Sure. I mean, it's actually pretty straightforward, which is, as we all know, companies act through individuals. So I think it's very important that we reflect that in how we're going about both our investigations and where we're placing accountability. That's kind of a technical answer. From a kind of a values and principle perspective, if we don't show that there is accountability for those who are most responsible for setting the culture, for okaying the fraud scheme, et cetera, then people rightly, I think, would lose faith in a system of justice that metes out accountability and ignores a category of those to be held accountable. So at the end of the day, this whole enterprise is about accountability and fairness. And so we have to show that there are not separate systems of justice here, and individual accountability is one important mechanism.
So another topic that is of great interest to our community is the use of monitorships. And it appears from comments you've made, priorities you've talked about, that the DOJ believes that the use of monitorships could be continued. Can you share a little bit of your thinking behind the value of monitorships to DOJ and how you're thinking about them?
Sure. What I announced back in October was a decision and a change in how we described how prosecutors and the lawyers here in the department should view whether and when to implement monitors. And the way I describe this is the move we made was to put that back into equipoise, if you will. There had been a change made previously to indicate and quite clearly state a affirmative disfavoring of monitors. And that is what a number of the folks who work in the space every day here at the department had. That's the guidance they were working under. The move we made was to say, no, we're not going to disfavor, nor are we going to favor. We are going to place that evaluation into equipoise and have it be a case-by-case determination, which I think is the right place for it to be. There is a value, and there can be a value in having a monitor. It's got to be evaluated on a case-by-case basis. What has been the practice previously in a particular organization? Have we identified through the course of our investigation a substantial gap that could be remedied by paying attention in this other way? So really, this is about having the facts and circumstances of individual matters drive those decisions. So we are neither disfavoring nor affirmatively favoring, but we see a role for monitors to play in appropriate circumstances.
So another thing that you actually talked about in the beginning of our time together is the importance of corporate culture. And that, of course, is something that is near and dear to the hearts of ethics and compliance folks, in part because we know from measurement efforts, ECI has done research around this, that when there is a strong culture in a corporation, the risk of non-compliance is reduced by as much as 467%. It's profound. And so one of the questions that we have for you is how the DOJ will determine if a weak compliance culture exists, and if a determination of that nature were made, would it be a material factor in your enforcement decisions?
Well, look, we're going to be concerned about the outcome or the results of what may be a weak compliance culture, right? We are not regulators, right? And that I want to be very clear about that. I think there can rightly be a concern by those who have to manage a compliance program and make sure, and this, particularly the financial services industry, is a very, very highly regulated industry. There's myriad organizations and agencies in the regulatory space here. That is not the job of the Justice Department. Where we find criminal conduct that reflects a weak corporate culture, or rather a weak compliance culture, part of remedying that for the benefit of the corporation and ultimately its shareholders, I think we should identify that and try and rectify that as part of the resolution. So, it's very hard to answer in the abstract. It's going to be driven by the facts and circumstances of an individual case. But I do think it's important to be clear that we are clear about the lanes and the lines that we occupy in terms of our enforcement mission.
So I know that you have a very tight schedule. I think I have only about a minute left of my time with you. So I just want to close with a little bit of a personal question, but what do you hope will be your legacy as a leader in the justice system?
Well, first, I hope that nobody uses legacy, the legacy word attached to me, because I would hope I'm a little too young for the L word, as it were. So, but what I will say is, my focus every day is on trying to make sure that we are going about our business consistent with the values of the Justice Department. As I said, I have tremendous affection. I wouldn't have come back into government if I didn't, and a real commitment to the mission of this great department, that we are pursuing its mission consistent with those values, and that we in government are making an impact consistent with those values, right? The value, I think, of being able to be in a position like this is to make change where it is needed, to have an impact that may not be felt, and you may not be something of great fanfare, but actually can impact real lives and real people. And that's the value, I think, of government service. That's what's driven me in public service, whether it's in this job or the myriad other jobs that I've had. So, and I hope, like all good leaders, I want to leave the place better than I found it. And I think that should be everybody's goal. So that's mine as well.
Well, from my vantage point, I think you already are building a legacy in the role that you have. And I just want to, again, thank you for being here, for engaging in conversation with me and with us. And thank you again. We appreciate your time.
Thanks so much for having me.
So while we are taking the video down from the platform, I first and foremost want to apologize to all of you for our technical difficulties. And I want to also thank the staff for their being able to stay cool under pressure. It's always the case that when a video like that freezes, at least one person it's an unflattering moment for someone. At least it was me and not the DAG. But I want to take a minute before we transition to the next segment to just talk a little bit about, excuse me, the piece that we skipped over. There was a little bit of a hop. So I want to explain what the DAG said. And I also want to point out to all of you that already this video has been uploaded to the resources section on the platform, particularly if there are members of the media that are present. You can access this video already and watch it all the way through. But you probably noticed that the DAG was talking about the Corporate Crime Advisory Group, the CCAG. The question she was answering is essentially she was telling us what they are doing, a bit about what they're doing, but also she was explaining that her office and the CCAG in particular have been reaching out to a number of different audiences to get input, that's an important priority for her. And we'll talk a little bit more about that in the next segment. But the other question that she was answering when we came back in is another one that I know is important to a lot of you. And that had to do with the DAG's announcing a priority in her October speech and in her memorandum that prosecutors will look more broadly at all prior misconduct, including criminal, civil, and regulatory, not just similar misconduct, which has been a practice in the past. And so the question I was asking her was, I made the observation to her that ECI's research has been that on average, 50% of employees observe some kind of misconduct in a given year. So if the DOJ is looking for instances of prior misconduct, they will surely find it. And the question that was posed by a member was, could we expect that the DOJ will factor in good faith efforts by corporations if they have implemented strong compliance programs when they are looking for instances of prior misconduct? And her answer was absolutely. So she was essentially, when we came back in, making the case that the DOJ prioritizes and values strong compliance programs. And she was saying, and for that reason, the time to invest in a good program is now. And so that, I think, hopefully summarizes the segment that we missed. And with that, I want to tee up the next piece, because it was intentionally, we created a companion conversation with two folks who very personally know what it's like to be a DAG, two members of the ECI board, but also just folks who I think have had a great deal of experience both in government and also on the other side of it in practice now. So Sally Yates As many of you know, today she is a partner for special matters and government investigations with King and Spalding. David Ogden is a partner and chair of government and regulatory litigation practice group at Wilmer Hale. Both of them served as Deputy Attorney General. Sally, of course, served as Acting Attorney General for a short time, but both of them came into the DOJ with a rich history as in the justice system. Both of them served a great deal of time with the Department of Justice. Both of them have a really rich experience of both what it's like in the role of DAG, but also in terms of thinking about the value of corporate ethics and compliance programs. I won't belabor going through both of their backgrounds. You can read their bios on the platform. Part of the reason we felt it was valuable to talk with them is that they both reviewed the videotape and then were able to speak to their perspective of some of the things that the current DAG was talking about when she spoke with me. Again, full transparency, this segment is also pre-recorded. We have also learned that not only is it difficult to get current public officials in the moment that you want them, it's hard to with former public officials. Both of them are very busy people. So we are going to transition to that video, and you will hear further some opportunities for you to give us some good input throughout the chat as this segment goes along. So let's roll that video. Great assets of the ECI is the presence of several former DAGs and officials from the DOJ who serve on our board, and we certainly appreciate especially being able to follow up with you and talk further about both DAG Monaco's comments in her segment, but also just your impression and your reflections of how things are going in the enforcement community at this time. So first and foremost, I just want to throw out a question to both of you. What stood out for you as you listened to DAG Monaco's remarks?
Please, David, you go first.
Oh, okay. Well, you know, I thought it was a great, terrific interview, Pat. You did a great job. You know, what jumped out to me was a portion where you asked the DAG whether you expect that the policies that are announced here by the CCAG would factor in that companies have taken good faith efforts to put into place strong compliance programs. And I thought the DAG's answer was really good to hear, because she focused on the goal being to have strong cultures of compliance in companies, but also that the department has a role in being able to arm the people within companies, the general counsel, the head of compliance, and so forth, in discussions with corporate leadership about the resources that are needed to have a first-rate compliance program. And she specifically used that term to help arm those who are in-house in those discussions to help build those strong cultures. And I do think that's a really important role for the department in thinking about fashioning enforcement policy. So I'm intrigued now to see what the CCAG does. I'm hoping that there will be not only the idea that heavy deterrence is what's needed to provide that arming with heavy punishments, but instead that there be real concrete ways in which those who've done the right thing and built those cultures and have those mechanisms and are doing the right thing actually are treated substantially better. So both things need to happen in order to provide that arming and for people to be able to say it's not just the right thing to do as a legal and moral matter, but it's the right thing to do for the company. So I thought that was really interesting, and I'm very interested to see what comes out of the process that she's launched.
Yeah, you know, I was thinking about her remarks both for this event and her speech that she gave a couple of months ago, announcing some policies. And I guess the takeaway I had from that was that this was a way of planting the flag that stepped up corporate enforcement is going to be part of this DOJ's mission. Mm-hmm. And she outlined some of the ways that would be taking place. And I expect others will come out of the advisory group as well. But sometimes it's tweaks around the edges that can signal things, whether you're talking about examining a company's full history or being more strict, for lack of a better term, on issues of violations of DPAs or NPAs, or clarifying the role of individuals and it not just being those who are substantially involved, but that a company needs to disclose the conduct of all individuals. I sort of viewed this as a way of planting, saying, you know, this is to put everybody on notice that DOJ is going to be fair and is going to follow the principles, but that this is a real priority for this department. And we are looking for ways to ensure that we are holding individuals and organizations accountable that should be held accountable.
So one of the topics that both of you have already raised is the CCAG. And actually, for the record, I got that acronym from DAG Monaco's office because she seemed a little surprised that I knew that acronym while her team actually shared it in prep conversations. But in our community, there has been a lot of discussion around what is this group actually doing? What are they going to produce? Should we be concerned that the guidance that has been previously put out by the DOJ is going to be blown up because this DAG, this administration is putting together a group to look at what the priorities should be? And so my question for the two of you is whether in your time in the DOJ, did you ever have such a group? And what insights do you have about what the current group may be doing? Your thoughts about how this DAG is approaching that? What can we expect?
Ellie, why don't you take this one first?
Sure. So I had a very similar group before we announced the individual accountability policy when I was DAG. And I think it's really essential that you get the input, not just staffers who are working in the DAG's office, but actually the people who are on the ground, so to speak, both in the components within DOJ and the litigating divisions, also on the investigative side, and then at other agencies. For example, IRS was a participant in our working group to think about what are we trying to fix? You shouldn't be changing policies just for the sake of changing policies. What are some of the issues that we're trying to address? What from a policy standpoint might make sense? And then let's think about practically how that is implemented and what that will mean in real life. And you really do need the input of everyone to be able to come up with the best recommendations. And so this is a common practice, not just at DOJ, but in other federal agencies to put together a group like this to examine existing policies. I don't think that necessarily signals some big sea change to come out of this. Sometimes it's nibbling around the edges and sometimes it is a sea change, but I wouldn't be too concerned that this means that they're going to upend all of the policies, whether that have been from the Obama administration or some of the good things that the Trump administration did, for example, in the additional guidance on compliance programs. I wouldn't be too concerned about that.
So one of the things that has transpired is that the ECI has been invited to take some practitioners to attend one of the listening sessions that the DAG's office will be having. And I assume that that is connected to the CCAG effort, which is great because as the DAG was mentioning, they are looking to get a wide range of insights and feedback from different communities, and we have been invited to the table. So two comments related to that. First, I want to invite members of the audience as they're listening to us, if there are things that you believe ECI should be raising when we are a part of that listening session, please put it into the chat or send it to a member of the ECI team. We'd love to have your input in that effort. But Sally and David, thoughts about what you think the ethics and compliance community might contribute to the CCAG? Any ideas of things that you would like us to see, you would like us to raise with the DAG's office?
I can say something, I guess, along those lines, and then Sally follow up. I mean, I thought you made an important point in conversation with the DAG that I think would be good to have be heard in this conversation, which is that human beings are involved in in any organization. As the DAG said, companies only act through people. But when there are people involved, there are going to be violations of law, even in the best company, even in the best circumstance. And I think your members know that very well. You can build the best compliance program, have the best kind of culture, and over time, something's going to happen that goes wrong. And so, while obviously a sensible enforcement policy needs to take that seriously, and when there's a violation, there needs to be an appropriate response. But to encourage companies to adopt the best systems, it has to matter that they've done that when those violations occur. And so in building that policy, I think it's important for them to hear from the compliance community that compliance programs matter, they make a difference, they reduce violations, they have everything to do with how a company responds when they detect a violation, self-reporting, root cause analysis. But the department has a role to play in encouraging that, and the policy should be built around encouraging that the best kind of compliance programs, recognizing that you're going to confront good programs even when you're dealing with violators.
Yeah, I think that's right. And having been part of these working groups before, or on the receiving end of recommendations and thoughts from them, I would encourage you, to the extent that you think there are things that are working well, that you point those out as well. Oftentimes people from the outside will come with their list of things they want to change. And consequently, some of the things that are working well can be lost in the shuffle and perhaps eliminated, because nobody at the department really knows that folks on the outside think that that's an effective thing. So I know there's always a premium of, okay, we got to use our time to complain about the things that we don't think are working well. I think it's really important for DOJ to get the perspective of those elements that some might say are unworkable, but from your perspective as compliance professionals, you found it works pretty well, because sometimes there's actually a tension between the compliance professionals and then what I'll call sort of the defense side, or even the general counsel, for example, at a company. I know, for example, after the individual accountability policy, I will not say that it was welcomed with open arms by the defense side of the community. I got a very different reaction from compliance professionals. Mm-hmm. And so I think that's an important thing too, for you to be able to draw those distinctions.
Mm. That's a great point. One of the things, when we do have opportunities to talk with DOJ officials, we often will say the compliance community should not necessarily be assumed to be on parallel with the general counsel community or the defense bar, because our perspective is very different. We see organizations and compliance from a completely different angle. It's a great comment. So I want to talk some about breaches of existing resolution agreements. The DAG has been very clear in her speech and in various speeches about enforcement against breaches of existing resolution agreements. And so what are your thoughts about that? But even more importantly, what are your thoughts about the factors that might help mitigate potential breaches?
Well, I think one thing, and I wouldn't be too alarmed about the breach side. Look, in any big company, particularly one that's operating all over the world, you're going to have employees who do something wrong. You can have the very best compliance program in the world. It can be effectively implemented, but somebody's going to screw up, whether intentionally or by mistake. But I think if what DOJ is looking for is not the one-off situations where individual employees color outside the lines, but rather situations that reflect that the company is not really taking seriously its obligation to ensure that it has put all reasonable mechanisms in place to ensure that employees are coloring within the lines, and that they identify those that are not. So, for example, we're representing a company now, enormous company, operates all over the world. They've had several violations during the time that they've been under an NPA. Those have all been reported to DOJ. They've all been remediated. And there's no indication that that means that DOJ is going to yank the agreement, because these violations that have occurred are not a reflection, I believe, of how the company does business, but rather aberrational conduct by individual or small groups of individuals within a very large company. And so if DOJ were to take the position that any one-off violation means that all bets are off and we're going to tear up the agreements, that would be an enormous problem, and frankly unfair. And so I expect and certainly hope that that is not going to be the approach at the department.
Yeah, I share the hope and the expectation. And I really do think that the department would, in thinking about recidivism, as I mentioned before, I mean, I think they need to think about how to talk about that issue, because I agree with Sally completely that all recidivism is not created equal, and I think the department's aware of that. But I think they need to talk about it in a way that reflects that. And I guess the only other thing I would say is, if you look at the things that the department is talking about when it's talking about compliance systems, I think you'll see things that I would hope would matter. Things like data-driven systems that are integrated into the compliance structure, and things like root cause analysis, which they're very focused on. So, I think there's things that are sort of more at the cutting edge, perhaps, that the department is thinking about. I think probably with the help of ECI in part, which has come in and shared its expertise over time about all of this. So I think paying attention to those pronouncements is important in thinking about how the department will look at recidivism when these things, as we've all said, inevitably do happen.
On a related, go ahead, Sally.
I would just say, and you're absolutely spot on, I think, on your point on root cause analysis. And to me, that all goes back to the fact that if the company's just trying to Band-Aid over a violation and not really get to the root of what caused it to begin with, then that's a reflection that this is sort of how they do business, and they're not terribly worried about that. So it kind of all comes down, at the risk of oversimplifying here, it kind of all comes down to that, to me, whether a company's actions, both in what the underlying offense may have been and then what they're doing afterwards, whether those actions are consistent with taking, again, all reasonable steps to be a company that complies with the law and regulations and holds its employees to a high ethical standard, recognizing that things are going to happen along the way.
So on a related note to root cause analysis, that is something that the DOJ has talked about for quite a while, has emphasized in past guidance documents, but I think practice within companies varies widely. And so in your minds, what is a good root cause analysis? What does that look like? So if a company is coming to DOJ, how do they show that that has been a part of not only this problem that has brought them in front of the department, but as a system across the company? Are there any thoughts you have, suggestions you have for companies around that?
I guess one thing I would suggest, I mean, I would hesitate to tell the compliance community how to conduct a root cause analysis. I think y'all, have a pretty good sense of that. It is this process of getting to the root and looking broadly, frankly, as well as very specifically, and looking at cultural factors and the like, as well as the specific mechanisms in a particular matter. But I would really encourage companies to have quite systematic record keeping in place about where they have detected violations and problems, where they have conducted the root cause analysis, what they did, what conclusions were drawn, and what was done about it. I do think that one of the things that we're hearing from the DAG in her speech, and she emphasized this again because you asked her about it, is that they're going to want to know about everything that's ever happened that's gone wrong at a company, and that sounds very scary. But I think once they see what that looks like, obviously they're going to make intelligent decisions about how much it matters. But I think, to Sally's point a few minutes ago, did you do a root cause analysis, and what did you do, and what changes did you make when you confronted these things? And I think to the extent you've got records to show that first of all, just keeping the record shows that you actually care about all this and you're able to describe it. And second, that you put in that you've done things that you can show so that with respect to each of these things, you can explain what you did to address the issue.
So another topic that the DAG talked about was use of monitors. And she said specifically, we are neither disfavoring nor favoring the use of monitors. What are your thoughts about that? I mean, it has been the DOJ's policy that when a monitor, the use of a monitor is imposed when based upon, in part, the state of a company's compliance program. Do you expect that trend to continue?
Sally, do you want to take that one or?
Sure. You know, I do think it's important to underscore that DAG Monaco was not saying, okay, now everybody gets a monitor,
Right.
but rather was trying to undo a statement that had been made in the prior administration that specifically disfavored monitors in all but the most exceptional cases. And, you know, as frustrating as this may be, I think for all of us that are now on the outside in the community, I think it's really hard to give a list of, you know, under these circumstances, DOJ will insist on a monitor. From my experience, it was when you felt like it was absolutely necessary to ensure that the company was going to fix what ailed them, was going to actually put things in place to address the systemic failures that led to the violations they had that brought them to DOJ's door. And certainly the company's history, the recidivism, how high the misconduct went, how pervasive it was, what type of compliance program they had in place both before the event and really importantly afterwards to remediate. All of those are factors that go into to play here. And so I think it's hard to say, you know, to give people really specific guidance on when they'll be required to have a monitor and when not, but certainly not only having a compliance program that's good on paper, but as we all know, that you can demonstrate is effective in its implementation. That has always been, and I'm sure will continue to be, a very significant factor in determining whether a monitor is needed in those situations.
One of the things that has been observed by ethics and compliance professionals and business leaders, you know, at large, is that monitors can be extremely helpful, extremely effective to a company, but they can also be very counterproductive. And one of the questions that I'm wondering that about your thoughts on is, are there things that the department can do to try to bring more accountability to the monitoring process, both in terms of selection of who becomes a monitor, but even evaluation? Is that something that either of you in your time in the department thought about? Do you have thoughts about what we could say to the DOJ now with respect to that?
From my perspective, I think the key, you know, to a successfully operating monitorship is this idea that the monitor, while independent of both sides, both the department and the company, is engaged in a process to make the company better, and that it is a productive mutual relationship with the company that is received that way by the company and that is thought about that way by the monitor. That it is an effort of improving the company, working with the company to improve the company, reporting back to DOJ in an objective way about what's happening. I think what DOJ can do, and I think the DOJ does this, at least my fairly limited experience, but my experience of doing one of them, is that the department does quite a good job. The key is the interaction by the department's representative with the monitor, and that there needs to be an open line of communication, I think, between the department with the monitor and with the company to get feedback about how the thing is going. If there's dysfunction, it could be on one side or the other. It could be on both sides. Communication is needed. The company's got to have the right attitude. That is really important. And if it doesn't, you know, in the end, the department's got to do something about it. But I think the department, if it can foster that, can encourage, look, you know, it's always the joke, we're from Washington, we're here to help, and that's sometimes received with a chuckle, but or worse. But I think that the monitorship idea, whether the monitors from Washington or somewhere else, they're here to help, and that what needs to come out of it, for all the money that gets spent on it, is a better company, and that's something that everybody hopefully is investing in. So I think the department, by being very engaged, can promote that.
And I think companies have a role to play here as well, because remember, the monitor is usually selected from the 3 names that the company has suggested. So be careful who you recommend, because not always, but most of the time, the monitor is chosen from those company recommendations. And it is really important that you have a monitor that looks at this as a positive, make the company better role, as opposed to just a gotcha monitor. And there is an aspect of reporting back to the DOJ if there are violations or the company's not doing it. But if you have somebody who has that reputation for being the gotcha monitor, you probably don't want to put them on the list.
And by the same token, though, Sally, right? You did this as DAG quite a bit. You selected a number of monitors, I know, but it's also got to be somebody who's going to have credibility with the department.
Oh, absolutely.
It's got to be both sides, right? The department will send your slate back
Right.
if the 3 that are on there are not any of them someone who they're prepared to accept in the circumstances. So it's got to be both. You've got to avoid the gotcha ones, but you do have to put up a slate that includes people that the department will see as legitimately independent, because that's the point of the thing.
No question about that. That's the most important factor, I think.
One of the things that we heard the DAG talk about several times actually was individual accountability. And so I feel I would be remiss if I didn't give Sally Yates an opportunity to say something about that. Your thoughts about that? She has clearly signaled that that is a priority for her. David, your thoughts too. What are some of the things that come to mind for you in hearing her discuss that?
Well, look, I think everyone recognizes that it's important to hold culpable individuals accountable for corporate misconduct. The question is always, so how you go about best doing that. And I think that with any kind of policy, you ought to always continually evaluate the policy and look at sometimes what some of the unintended consequences might be of how things are carried out in real life. But look, I think it goes back to the department's fundamental promise of equal justice, that you can't have a system that pursues individuals when they commit one type of crime, whether you're talking about, street crime, drugs, property crimes, but yet in another context where the crimes are committed in the boardroom or in an office, those people are treated qualitatively differently. That's not equal justice. And so I think it does go back to the department's mission there, and ensuring, again, that those people who are responsible for criminal conduct within an organization are held individually accountable. It's nothing gets people's attention like somebody having to go to prison. One of the experiences has been before that, companies oftentimes will write a check, but that doesn't have a really big impact when it comes to deterrence. But it is equally important that people only go to prison when it is fair and just that they do so. And so I think that is important, that we continue to monitor and calibrate and make sure that this is being approached in a balanced way. And I'm confident that this Department of Justice will do that.
So I guess I would only say, Pat, I mean, I'm a huge fan of Sally Yates and of Lisa Monaco both, and think the world of the way both of them have gone about being DAG. On this one, I think it goes to the issue goes to the point that Sally made a minute ago. It's about sort of the unintended consequences of how you structure something. And I think, to me, the challenge of this one, I agree with everything that Sally said in in talking about this, the importance of equal justice, the importance of sending a message to the real wrongdoers. I think the question comes in is if you're conditioning sort of an all or nothing cooperation concept around identifying all persons involved and taking out the substantial involvement. I think the question is, what impact does that breadth of requirement have on companies' willingness to cooperate and on and the risks that are associated with making decisions if people aren't substantially involved, which was one standard, but are merely involved? Are you really talking about identifying, you know, the wrongdoers, or are you identifying minor players and causing companies to hesitate to cooperate? And I think it's a debatable thing. It's kind of an empirical question, I think. There's probably good arguments on both sides, but I think that's the question that gets raised by this particular policy. It's, you know, in having this seriousness about individual accountability, are we making it more difficult for companies to cooperate? I think that's really just the question.
One of the things that I heard Lisa say in her remarks that I thought was very interesting was she was talking about we are not regulators, especially as we were talking about culture. She is very clearly emphasizing the importance of having a strong compliance culture. But then when asked, what does that look like? She says, we're not regulators. And so I wonder what your reaction was in hearing her talk about that. I think it harkens back to what you were saying, Sally, about the mission of the department and having a clear understanding about their understanding of what does the DOJ do? What's its purpose?
Yeah, and certainly Lisa is right that the Department of Justice is not a regulator. On the other hand, the department historically has and continues to have policies designed to encourage certain law-abiding conduct. And here, for example, where we know that an effective compliance program is really essential to ensuring that a company has a healthy culture and is less likely to be engaged in criminal conduct, the department's lever, so to speak, is to be able to give substantial credit for that compliance program when having to make a decision if something has gone off the rails. And so I viewed it more as her saying, look, we're not going to get into the nuts and bolts of prescribing exactly what a compliance program should have, but yet the department's guidance in the evaluation of compliance programs gets pretty nuts and bolts in terms of these are the things that we're going to be looking at and determining whether or not you should get credit for an effective compliance program. So I just sort of viewed it more as, look, don't be looking to us to give you every little jot and tittle of what you ought to have, but yet there are certain parameters of if you want credit for it.
Yeah, and I agree with all that completely. I really do think that it's fine to say that the department's not a regulator. It isn't in a formal sense, but I think there was a clear recognition in what Dag Monaco said, that the department's policies have an impact on how companies behave, and that is kind of regulation, right? And you have to proceed and have policies in place that create virtuous incentives and not perverse ones, and regulators have to think about that, and I think enforcement people have to think about that, and I think that is what they're thinking about. I was really heartened to hear the way, and not surprised, but pleased to hear the way she was thinking about that.
So we have just a couple of minutes left. So I have one last question for both of you. One of the things that I think was particularly impressive was that Dag Monaco noted that in some of her public comments that she knows it's difficult for compliance professionals to get the time and the attention and the resources they need to effectively run their programs. Based on your experience, both within the department and now on the other side, what message or advice would you have for ethics and compliance professionals that are trying to get that attention within their companies? How do they make the case about the importance of what they do?
I'll offer one thing and then let Sally have the last word here. I guess the one thing I would offer would be, well, let me make it two. One, pay attention to what the department is saying about the fact that they care about this, that they're going to be focused on this when they're thinking about dispositions, both civil and criminal. And they're telling you they're telling you what you should be doing. There are guidelines there about what kinds of programs are needed. They need to be real, like Sally said, not paper programs, and they need to have teeth, and they need to work, and they need to be resourced, and the department's serious about that. That would be A. And then B, with a tip of my cap to Sally, people go to jail, you know, and there's a focus in this administration in particular on senior leaders who fail to do the right thing. And the best way to be on the right side of that is to be a champion within the company for first-rate compliance.
Yeah, I think David really captured it all. Perhaps this would be too blunt, but to me, if a company is not resourcing its compliance program, if it is not giving sufficient authority to people who are implementing that compliance program, then that's a reflection to me, if I'm on the DOJ side, that they're not really serious about this. If this is the first place that they start cutting when times get tight, then it's sort of all going back to is this how the company does business, or is it aberrational thing? If they're just putting together this compliance program for show, so they have something to trot out if they need to at DOJ, that's going to be reflected in the fact that they're not resourcing it, and that's the first place that they start cutting. And so I think that sort of is one thing that DOJ does and should look at, to me, to determine the authenticity of the company's commitment to compliance. It's not enough to say it. You got to put your money where your mouth is, so to speak. And I think that's something that's a really important factor for the department.
Well, thank you both again for joining us, for sharing your insights. And I also just want to take a moment and thank both of you for your leadership and your involvement with ECI as a part of our board. Our community benefits greatly from the wisdom that you share very often within our organization, and we're so grateful for the time you give to us. So thank you again.
Hi, everybody. My name's Ernie Broughton. I'm a senior advisor with the Ethics and Compliance Initiative. And it's such a wonderful, unique opportunity to celebrate a centennial anniversary with an organization as an employee or as a member or a stakeholder. I'd like you to view a short video announcing ECI's centennial milestone.
Our story begins in 1922. Women had recently won the right to vote. Nationwide adoption of workers' compensation had begun, and the U.S. was growing rapidly. Through the Depression, the Second World War, and a post-war population boom, society's values and ideals changed. We were hard at work, helping shape the values of new Americans and the next generation. In the 70s and 80s, companies gained ever more wealth and power, creating a growing expectation that they define their obligation to society after facing a loss of public trust. ECI was right there, helping to develop the first code of ethics for United States government service and the first in-house ethics department, bringing public attention to workplace conduct, which was necessary for business success globally, and creating the first community for ethics and compliance professionals. In the 90s, business leaders and federal government officials realized the need to formalize business ethics, creating a new profession. At the turn of the century, our ethics practitioners and academic researchers shared best practices and data about the state of organizational ethics, making ECI a common voice and the community for networking and knowledge sharing. As ethics programs and workplace integrity initiatives became more established, we convened industry thought leaders to define the role of Chief Ethics and Compliance Officer, met regularly with the legislative and enforcement community, and created a vehicle for candid dialogue between officials and practitioners. For 100 years, ECI has continued to raise the bar for the ethics and compliance profession. We've elevated corporate integrity, empowering organizations to better themselves so they can better the world. We are proud of all we've accomplished together. Our story is your story too. Come celebrate with us a century of integrity at work and the endless possibilities ahead.
I also had the privilege to speak with Larry Thompson, the ERC board chair, Steve Scarpino, ECA's board chair, and Pat Harned, our CEO, about the importance of ECI as an organization and the significance of this milestone. So join me in that conversation. Board chair and former United States Deputy Attorney General under George W. Bush. Also, Steve Scarpino, the Ethics and Compliance Association board chair and the Chief Ethics Officer for Citgo Petroleum Corporation. And also Pat Harned, the Chief Executive Officer of the Ethics and Compliance Initiative. Welcome. You know, our opening video featured a lot of exciting milestones during our first 100 years. Writing the first code for executive branch employees, launching the first association for ethics and compliance professionals, and conducting research on the state of ethics in organizations throughout the United States and globally. One of the things that we've realized as we've reflected on this centennial milestone is that the history of the Ethics and Compliance Initiative is very closely aligned with the history and the growth of the ethics and compliance profession itself. Our story essentially is everyone's story. So I'd like to hear how each of you got involved with the Ethics and Compliance Initiative. What's your ECI story? Larry?
Hello, Ernie. I first got involved with ECI several years ago. I was the general counsel of a large public company, and I was leading an effort to revamp and expand our ethics and compliance effort. Pat and her team were very helpful to us. But more importantly, it was then that I first realized that one of the most important assets a company can have is a strong and positive ethics culture, a culture that emphasizes not only ethics, but candor. And Pat and her team were very helpful in this regard.
That's great, Larry. Thank you so much. What about you, Steve? How did you get involved with ECI?
Thanks, Ernie. It's hard to believe it's been almost 20 years ago. It was 2003. And I was appointed as the Ethics and Compliance Officer of a Fortune 500 company with absolutely no experience in ethics and compliance. And the first place I turned to was ECOA at the time, the Ethics and Compliance Officer Association, which is now part of our ECI. And I just found it to be a tremendous organization with some of the pioneers in our field. People like Kerry Penman and Pat Nazo and Ed Petrie, Joan Dubensky, Gretchen Winter. I think of those folks today, and they're still very active in what they do, but they really helped me learn what an ethics and compliance program was. And I was also very impressed with the organization on how much they were willing to share. I always felt that when you have really difficult issues to deal with in ethics and compliance, sometimes you couldn't necessarily even deal with them internally. You wanted to reach out to somebody on the outside. And these were the kinds of people I could call regularly and say, hey, have you ever come across an issue like this? So I found that ECOA was just there for me. And now I'm at a point where I'd like to give back to the organization that gave so much to me during my career.
Thanks, Steve. That really resonates with me, you know, the community of practice, basically, that we grow up with and grow through. Pat, what about you? You've been at ECI for 20 years?
A long time. I came in 1999 as a staff member to then the Ethics Resource Center. We adjusted our names after we created the strategic alliance between ERC and ECOA. But I was brought in to help grow a function that was doing outreach to the next generation of workers. I had been in education, had done my PhD, and looked at how organizations influence people's moral development, their character development. And so I came to start a new function, but I also arrived at the time that the Sentencing Commission was revising their guidelines to ask organizations to be able to demonstrate effectiveness of their ethics programs. And it wasn't long before I became more involved in our research work and a lot of the outreach we were doing with companies as they were growing their E&C programs. So I came into leadership of the organization in 2004, and have just been unbelievably fortunate to help lead the organization as we have combined these two great nonprofits to leverage the strength of both, and have really started to build a bright future for ourselves.
Great, thank you so much, Pat. I'd like to ask Larry, why is the ECI still relevant today?
Yes, Ernie. I think ECI is more relevant today than it ever has been. It's been my experience that investors are really fed up with the loss of shareholder value because of the corporate scandals, because of bad corporate cultures. ECI clearly understands this. ECI understands how to build and develop strong, positive corporate cultures. ECI is an independent organization. It's a not-for-profit organization. Its work is supported by years of independent research. ECI has credibility with regulators and enforcement officials. And really, I've come to believe, based on my years of experience, that ECI is very important to our capitalist system, in that it helps ensure that the United States is the very best place in the world to invest.
Thanks, Larry. Yeah, I think that the independent voice and the objective voice of the ECI adds unique value today. Steve, one of ECI's big accomplishments over the last few years has been the work that we've done to frame the conversation around high quality ethics and compliance programs. What's your view of the future for program effectiveness and best practices?
Thanks, Ernie. Well, first of all, I think that, ECI has just done a tremendous job with putting together the HQP framework, which allows organizations to assess the effectiveness of their ethics and compliance program. And the thing is, it's kind of a living document. In fact, we expect that we will, as part of ECI, continue to improve upon it. And what I love about it is the fact that, it's not just a practitioner's view, it's also the educator's view. It's also government agencies as they provide more and more insight on what they're looking at, whether from an enforcement perspective. It's that collective audience that is so helpful in putting together that framework. So the other good news about that, I think, is that we've had a number of ECI partners sign on within the last 6 to 9 months so that they can have access of the tool for their customers as well. It's also my understanding within just since January, we've had at least 130 organizations that have actually assessed their programs against the HQP framework. So I think there's just a tremendous value to that. And I think as you think about that framework, whether it's for yourself as an E&C practitioner, whether it's for your ambassadors that work within your organization, your leadership, your board members, and I even think it's a good tool for corporate monitors to be looking at as well as how they assess programs. So I think that the future is very bright and it's very relevant, and that is a living document that we will continue to use those constituents to help us move it forward.
Thank you so much, Steve. Pat, at the threshold of crossing the 100-year anniversary for the ECI, how do you think about the future for our organization?
Well, I think at the staff level and at the board level, we are thinking about not only the milestone we've achieved. It's pretty rare for a nonprofit to actually reach the centennial milestone, but we're starting to think about what's the next 100 years for our profession and for our organization. And it builds on the two things you just heard Larry and Steve talking about. First, investors are fed up, and a lot of customers and employees, they're looking for a higher standard of responsibility in corporations and the organizations they're working for. And at the same time, our profession is building a framework and doing a lot of deep thinking through the HQP and even beyond HQP as we think about what is best practice. How do you transform an organization? What is the role of ethics and compliance and risk management and this ever-growing momentum that is ESG? And so as we think about where are we going as an organization, there's a lot of room for a community like ECI to take a leading role in the dialogue about how organizations approach not only bettering themselves as workplaces, as cultures, but also bettering the world through the ESG efforts that they're undertaking. And so that, in a very small nutshell, is how we've started to think about the future for ECI, that we have a part to play in helping organizations better themselves so that they can better the world.
Thank you, Pat. Well, it's an exciting time to be a part of the Ethics and Compliance Initiative, and to have our members basically a part of that journey. And so thank you for being here and talking about the importance and the value of this moment in the history of our organization and our profession. And so, Pat.
Ernie called me out, and so here I am. Everybody, I know we are going to start our breakout sessions at 11:35. So if you would indulge me for just 2 minutes, I want to tell you a little bit about what our plan is for celebrating our centennial. And all of you are a very big part of that. So first and foremost, please take a few minutes and visit the Centennial booth in the virtual exhibit hall. But here's what you can expect. And we also are looking for your input. Over the next year, we plan to gather our friends and colleagues, both current and former, in virtual and in-person reunion events. You see here a list of some of the folks that we are already thinking about trying to get together, bring in folks who have retired from the field, moved on from the field. We're interested in your input about other groups that you would like for us to host reunion events with. We have in our archives, thanks to both the ERC and the ECA, we have about 1,000 research reports, working group reports, rich resources that have been archived over the years. And so our plan is to go through those documents, pull out the ones that are still evergreen, update them, and send them back out to our members. Because there's nothing like learning from the great work that's come before us and utilizing it again today. So we look forward to being able to open the vault, if you will, and share those resources with you again. In many ways, you heard only a snapshot about our history, but our history is the history very much aligned with the profession. And so we also plan to commemorate our history, to share that with all of you, because we think it will be a very helpful educational tool for all of your professionals, just in reminding them of from whence we have come as a profession, but also pointing out some of the good work that this organization has done. And then I would like for you to plan now that this time next year, Impact 2023 will be an in-person event, pandemic willing, but we plan to host it in the New York area. You may not know, but we got our start in 1922 by helping to educate both folks coming into the country, immigrants coming into the country, people in the United States about the values that are undergird the foundation of the United States. And so we think it's fitting to return there next year. We plan to host Impact 2023 in that region, and we plan a gala event at Ellis Island, which is one of very much linked to how we got our start as a nonprofit. So again, I invite you to visit the Centennial booth. We're interested in having folks sign up as volunteers as we look through our resources to distribute them. We're looking to plan these events. We welcome your input too. So with that, I want to begin to close out this morning segment. Again, thank you for your patience with some of our technical difficulties. I also want to point out that for each of our keynote sessions, we have a sponsor. Thank you to Conversant for serving in that role for this morning segment. And then I want to invite you to attend the breakout sessions, and we will see you there. Thanks, everyone.